The record should show that members of the jury have returned to open court. Counsel and Mr. Burns are present. We are ready at this time to hear any closing arguments from Mr. Spies on behalf of Mr. Burns.
Thank you, Your Honor. May it please the court, counsel, and Jerry Burns. I am pleased to be here to speak on behalf of Jerry Burns. When I had a chance to speak with you about 2 weeks ago, I talked about the encounters that we have day to day, people to people, people to objects, objects to people, and the exchanges of genetic information that we share every day, and how that genetic information tells us much about what we are, but not necessarily who we are or where we've been. Much of this case, as we've heard over the last 2 weeks, talks about the diligent efforts made by law enforcement over the past 40 years to try to uncover the secret about who killed Michelle Martinko. And there is no criticism about the diligence of that efforts. But importantly, as I mentioned to you again 2 weeks ago, it's our contention that the evidence shows how that path, that investigation took a divergent turn, and that turn has inevitably led wrongly to Jerry Burns, and why Jerry Burns is not guilty. Michelle Martinko was a vivacious, attractive, talented young woman in the bloom of life. And in 1979, when she went to the Sheraton Hotel in Cedar Rapids, Iowa for the choir banquet, and then either by boredom or in search of a coat that had been set aside for her by her mother to Westdale Mall, she had every expectation of a full and vibrant and enriching life. Now we know from the evidence in this case that the investigators showed and were able to determine, and from the testimony of her friends, that she went to the Westdale Mall, she encountered a number of people that she knew, either from school or elsewhere. And during the course of that time, she spent 40 to 50 minutes with Kurt Thomas. And you remember Mr. Thomas talking about how he had left his job there at the Westdale Mall, that they walked around the mall together, went to the Orange Julius where Mr. Thomas had something to eat. We also know from Andy Seidel, Michelle's former boyfriend, that about 4 days before her death, she had expressed to him her fear and her concern about a grotesque or an ugly man who had been stalking her at her job at another mall. But as Kurt Thomas and Michelle walked around the Westdale Mall, went to the Orange Julius, sat down with Mr. Thomas eating, we know that they sat on a chair or they sat on a bench. Mr. Thomas, we know, had something to eat. We don't know whether Michelle had anything to eat, although the autopsy report showed that she had undigested food in her stomach and undigested food in her esophagus. As she walked throughout the mall, she encountered still more people. She saw benches, she saw chairs, she saw counters, she touched objects in stores, she touched objects throughout the mall. We also know from the evidence that as she left the mall, somewhere between 9:30 and 10 o'clock, the mall closing time, she would have walked up to an exit door, pushed that door to go out of the stores. She was not wearing gloves. We know that from the evidence and from the photographs of the crime scene. She had a scarf around her neck, knotted around her neck. As she went out to her car, there were no witnesses to what happened there. Hours later, when investigators came to the scene in search of where she might have been, they found her huddled in the lower part of the passenger side of the car, dead from multiple stab wounds. She was in her parents' car, a car that her mom and dad had driven. She, of course, had been brutally stabbed, and as we know from the autopsy report and the photographs, all of the stab wounds, except for a couple, were inflicted and penetrating open flesh, which is an important thing for us to remember as we go along in tracking what happened that day. We know also as well from Dr. Feaster and from the investigators that there was no evidence that this was a sexual assault. The investigation and the evidence that pursued the tracks and the trails that we're going to be following in the next several minutes all stem from the supposition that Michelle Martinko on December 1979 was targeted. Her assailant had rubber gloves. He had a substantial knife, or she had a substantial knife. She had been followed. Had been stalked, and she was targeted. She was targeted. The evidence shows, and I'm not going to catalog it exhaustively because you've listened to it carefully, the investigators showed that whoever was equipped with these instruments of death was prepared and carried out a mission that had been accomplished only by preparation and planning. The wounds, in fact, aside from the wounds that were intended to kill her, were intended to disfigure her. Now, investigators found inside the car that the car interior was blood spattered. There was fur throughout the car from her rabbit fur coat. They also found that there was no trail of blood or blood drops around the car, no indication that someone had carried out blood outside the car or had left a trail of blood from a wound. We also know that in moving the car that night, investigators had to get inside the car, turn the ignition to on, turn the shifter to neutral so that the car could be towed to the Cedar Rapids Police Department. Now, throughout the investigation that ensued from that point on, the handling of the evidence, the integrity of the evidence is critically important. Because remember, we're dealing with a situation involving cells, involving genetic material, involving minute pieces of evidence. And all of that evidence has to be carefully handled and carefully considered throughout the course of the entire investigation. We know that at the autopsy that Michelle's clothes were taken off from her. They were turned over to investigators from the Cedar Rapids Police Department, where they were then taken to the Cedar Rapids Police Department to be dried and cataloged. The course of that evidence from that day forward is critically important to your consideration of both the integrity of the investigation, the integrity of the evidence, and the uses to which that evidence has been put in this case. Over the next few decades, we know from Investigator White, from Investigator Kincaid, from the criminalists who examined this evidence in Des Moines and Ankeny, that the evidence, specifically the clothing, was bundled together. Now, why is that important? We know from investigators who testified about their long experience as identification officers that bundling together of items like that is not proper police procedure. Why? Because it leads to the cross-contamination of items bundled together. Now, much has been made in this case about whether or not there was any outside influence or any outside contamination. And I don't believe that there probably is any evidence of any outside contamination. But within the bundles of clothing, as you heard from Dr. Spence, you heard from Mike Peterson, that there was a very real danger of the exchange and the distribution of genetic material, which is going to be important throughout the course of your consideration and your evaluation of this case. And it's because of this very real danger, as Mike Peterson described it, that we have urged you to be especially attentive to the way the evidence was handled and the uses to which that evidence has been put. Now, again, I'm not going to exhaustively catalog the evidence that you've heard throughout the course of this case. You've been studious and very attentive to the details and the importance of the details that you've heard from the testimony and from examining the witnesses. I do want to recall, as you all know, that we've heard from Dr. Spence, we've heard from a number of other witnesses that as we go about our day-to-day activities, that there is an exchange, possibilities of exchange of genetic material. We could probably go to this microphone and find the genetic fingerprints of everybody who's testified during the course of this case, on your bench rail, on your hands, on the chairs that you've been sitting in. We know from the testimony of Richard White, one of the first investigators on the scene and the one who kind of supervised the investigation, that when he gathered up the material and had it placed into storage in evidence of the Cedar Rapids Police Department, that care was taken to make sure that it was maintained in a proper stored facility, in proper stored conditions. But remember when Dick White looked at the tag from Exhibit 17K, looked at the packaging, he said that I never would have signed that D White, I would have signed it R White. We know from Dennis Murphy, the investigator who repackaged this material in 1996, that he couldn't understand why there was a discrepancy between the dates of December 1979 and December 1980. Murphy speculated that perhaps the material hadn't even been packaged during that entire year, and that was being packaged for the first time in 1980. Now, of course, we don't know that that's not the case, because we know that in early 1980, the dress was sent off to the FBI laboratory in Virginia for determination of whether the blood on the dress was human blood and what type it was. But somewhere between December of 1979 and December of 1980, this material had gone to the FBI laboratory, returned, but we don't know where and when it had been during that period of time. We also know from Mr. Murphy that in December of 1996, he repackaged the evidence. It was bundled together. He was uncertain about exactly where it had been during that period of time, but nonetheless, it had been bundled together. And again, as Mike Peterson said, and other witnesses have testified, that bundling together created a real danger of contamination within that package. In January of 1997, the evidence was sent to the Division of Criminal Investigations Laboratory in Des Moines, where Mike Peterson examined the dress, the pantyhose, and the panties. Again, it was sealed up in one big package, and Mr. Peterson testified that he looked through it. We also know from his testimony that in examining that material, he also looked at the shifter with the extract of the blood from the shifter, item I. In 2003, we know that Linda Sawyer also examined the same items. I'm not going to exhaustively catalog all the examinations that took place, but when she examined the material in 2003, again, she had seen it in 2002, she noticed that the scarf and the pantyhose at this point were back in that package. Importantly, she did not examine either the scarf or the pantyhose. We also know from testimony throughout the course of the trial that when she was looking at the panties, she found a few spermatozoa that were recovered from the crotch of the underwear. An effort was made to determine whether there was any genetic material available for testing, and at that time, in 2003, there wasn't enough there to determine a DNA profile. Through 2002, 2003, and on into 2005, this material was packaged and repackaged. And you remember, you hear, I believe, both Paul Bush, who came in on rebuttal, and from Dr. Spence, that the packaging and repackaging, especially if the material is dry inside, can cross-contaminate. It can become brittle, break off, relocate within the fabric of the material that it contains. All of those are important matters. Now, Dr. Spence talked about the handling and the repackaging, the transfer of genetic material between items bundled together. This is not just phony stuff or something that was made up. This is important scientific information that's invaluable and necessary for your critical appraisal of all of the evidence in this case. We're resting, remember, this case on cells, on genes, and based on the small, minute amounts of information that are being transmitted between items of clothing or between objects and clothing, between persons and objects, all of that minute detail is extremely, extremely important. We also know, as we narrow down here on the critical items of evidence, that in 2005, when Linda Sauer examined, again, the dress, the pantyhose, and the panties, and once again, these items were bundled together. We know that she identified some additional spots, both on the front and the back of the dress, item 7A. She described in detail how she had gone about doing that. She used what she described as an alternative light source to try to find difference in textures on the dress, and that's how she was able to spot the blood spot that we're going to be evaluating here in just a minute, item F5. We also know she described in detail that she had used a swab to presumptive test to try to find out if the spot that she had located was blood. Remember, she had used two different types of presumptive tests to identify that F5 was in fact blood. Then she took a cutting from that spot to try to get some genetic material from that spot. Item F5 is probably the most important spot in our determination of the integrity of the evidence, and most importantly, the conclusions that are drawn from that evidence. We know that this spot was not discovered until 26 years after the murder. In that 26 years, again, the dress had been packaged, repackaged, examined, re-examined, repackaged multiple times. We also know that in those years, not only had the material been packaged and repackaged, but it continued to be bundled together over and over again. The number of times that it was repackaged, we don't know for sure. We know that it was repackaged in going to and from the FBI in 1980. It was repackaged and being sent to the DCI lab in 1997, again in 2002, 2003, and again in 2005. And when Linda Sauer screened it positive for blood, we know that she used, as I said, a presumptive test, two presumptive tests, that even she could not conclude from the DNA material that she was able to get from that one tiny cutting whether that male profile DNA came from blood, or whether it came from saliva, or whether it came from mucus, or it came from sweat. Again, it's just not Dr. Spence's opinion about this. It was the same opinion reached by Ms. Sauer in her careful review in 2005. Now, importantly, the question has been whether or not that stain and the male profile, later determined to be Jerry Burns' profile, came from blood. Repeatedly, the prosecution has characterized it as blood. Dr. Spence, as he sat here and described it to you, noticed that the extraction note that Linda Sauer had used in identifying the amount of information that she was able to get from that small cutting on the back of the dress, the bottom of the back of the dress, said that there was 0.062 nanograms per microliter of DNA extracted from that spot. Importantly, he was not saying that that was blood or that was an indication of how much blood was present at that stain. But what he told you, as you recall, is that based on the amount of DNA that was extracted from that spot, he would have expected that there would be a lot more DNA if it had been blood. Not that that's an indication of how much blood was there, but merely an indication of how much DNA was in that specimen, and that there would have been a lot more DNA if that had been blood. The conclusion, the scientific conclusion, is that the spot there, the stain containing Jerry Burns' DNA, was not from blood. We also know this in part because in years afterwards, when 4 additional cuttings were made from around F5 by DNA labs, they were unable to find any DNA at all. Now, it may have been that in the course of the flood of 2008 that any humidity or moisture may have eradicated that DNA if there ever was any additional to be found there. But importantly, as Dr. Spence pointed out, when Linda Sawyer used those 2 presumptive wet swabs to test for blood, it may have been that in doing that, she eliminated any existing DNA at that spot. The importance of that is this. Whatever DNA was there was scant. There wasn't a huge blood stain from Jerry Burns at the back of the dress, and particularly in the very unusual spot where that spot was found. Whatever was there was something other than blood. And that's what the science tells us. Importantly, when Paul Bush came in on rebuttal with the big picture of the investigation that took place at the Iowa Division of Criminal Investigation Laboratory, even Paul Bush said that based on what was there at spot F5, not only could we not determine what biologic material that came from, but there was no other tests of the dress for any other biologic material that might reveal a male profile. And that's important, and you'll see why. We know that no other items were ever submitted to the Division of Criminal Investigation after F5 was determined and found by Linda Sauer. And that's important, again, from the instructions that the judge has just given you. We also know that item I, which is the extract of the gear shift, was another source of a male profile, and of course, presumably of Jerry Burns. In the examination of that gear shift, everyone who examined it, analyzed it, said that it was a mixture of the DNA. And the important information we learned from Ms. Sauer and from Paul Bush was that mixture, again, could not be determined to be a mixture of blood from one person and the blood of another person. That the partial male profile found at spot I, the extract from the gear shift, could again have arisen from sweat, from saliva, or from mucus. Or importantly, as Mike Peterson said, from skin cells that found their way onto the gear shift. Now, you'll recall that Linda Sauer was somewhat confused about whether she actually examined the gear shift itself or whether, as Mike Peterson did, she had the blood extract from that gear shift. But notwithstanding whether she looked at the gear shift itself or the extract from that gear shift, she too could not conclude whether or not it came from a biologic source other than blood. Finally, as we know from Mike Schmidt, the male profile on that, based on some errors in reporting, could no longer be reportable to the standards of the DCI. The integrity of that evidence has been called into question. Judge Hoover has told you that in considering the existence of whether or not the state has proved its case by evidence beyond a reasonable doubt, you can consider not only the evidence, but also the lack or the failure of evidence produced by the prosecution. And it's our belief that the lack and the failure of important items of evidence in this case are critical to your consideration of Jerry Burns and his guilt. We know from every witness who has testified that the scarf that was found around Michelle Martinko's neck was never, I repeat, never tested. Why is this important at all? We know that the scarf was knotted around her neck. Dr. Feaster testified about that. And we also know that that scarf was the closest item of clothing between Michelle Martinko and the knife that inflicted her wounds. It was the closest item of clothing between Michelle Martinko and the assailant who killed her. And yet that scarf, removed from her body by Dr. Feaster, submitted to the Cedar Rapids Police Department, packaged up at times, sometimes not packaged up, was never examined for the presence of any biologic material by any male or anyone other than Michelle Martinko. We also know that the steering wheel from the car, from which a tape lift was made by Richard White, the tape lift that was obtained from that steering wheel was insufficient to find any DNA whatsoever. And yet, as we know, the steering wheel was rich with blood. No further efforts were found to extract a blood sample for any male profile. Amazingly, not only was there no DNA found in the tape lift from that steering wheel, even Michelle Martinko's father's profile was presumably never found on that steering wheel. The panties that were examined by Dr. Feaster said that during his autopsy, a pap smear was done. There was no evidence of spermatozoa or semen found on Michelle Martinko's body or in her body. And yet the panties were examined by Linda Sauer in 2003 and found to contain spermatozoa. This isn't just something that we phonied up to create an inference of doubt, but importantly, even though that sperm was identified in the panties, in 2003 there was no identifiable male profile found based on technology at that time. But we know from all the witnesses who've testified about the evolution of genetic analysis, the evolution of investigations involving genetic material, those items could have been re-examined, but they were never retested. There is, in fact, evidence of another male at this crime scene. The dress about which we've heard so much and the evidence that was extracted from that dress, we know from both Paul Bush and from Dr. Spence that there was no further testing done front or back for anything other than blood. It's been exhaustively established, men and women of the jury, that saliva, that mucus, that sweat contains genetic material. And all of that genetic material carried answers to the question of who killed Michelle Martinko. That evidence could have been found in the front of her dress from the exertion of her assailant, from yelling or screaming or sweating. It could be found on the front of her dress, it could be found in her scarf. It was never looked for. As Paul Bush candidly said, you can't find what you don't look for. And that evidence was not looked for. So the concentration of the focus of this case has been on F5 and on the extract from the shifter, item I. Based on what was found in those locations, that's where the concentration of this case has gone. And it's our belief that it was the diversion based on that that led to a path to Jerry Burns, but not the path. We've heard impressive statistics about the match, the likelihood of a coincidence, 1 in 100 billion. We also heard from Ms. Nash at Bodie Technologies about the inference that can be drawn from the profile found when they re-examined the extract from item I. But again, these statistics are based on an assumption, and that assumption is that F5 is the spot of the killer, that I is the spot of the killer, and that there are no other plausible explanations for where the genetic material that may be on this dress that had never been located, where those statistics might go wrong. We also know that based on the investigation that Investigator Dendlinger pursued, that he contacted Parabon Nanolabs. Parabon Nanolabs constructed a likeness that was used to try to generate additional leads. And again, we find no fault with that course of investigation. It was creative, it was resourceful, important, but in the end, based on the assumption that F5 and I were the genetic material of the killer. We also know that Parabon was again recruited to develop a family tree, and that the family tree was in turn used to identify and locate the Burns brothers. From the Burns brothers, a straw was obtained from Jerry Burns. That straw was used to develop a profile from his genetic material, and that genetic material was then focused on him. So what about Jerry Burns? Well, we know from the investigation done by the Cedar Rapids Police Department and from his own interview that in 1979, he was a young father, married with, at that time, 2 young children, living in Manchester, Iowa. Manchester, Iowa, the county seat of Delaware County, is about an hour away from the Westdale Mall. We also know from the testimony of Investigator Dendlinger and from Jerry's own interview that he was working in Elkader, which is north of Manchester. He worked in Elkader as working for a feed supply company as a salesman. Again, a significant distance away from Westdale Mall in Cedar Rapids, Iowa. The scenario that has been developed by the prosecution in this case is that Jerry Burns, on December 19, 1979, drove from either Manchester, Iowa, or Elkader, Iowa, to the Westdale Mall, that he was bent on the destruction of Michelle Martinko. Not only was he bent on her destruction, he had planned to have rubber gloves and a knife to inflict the fatal wounds that killed Michelle Martinko. Now, we do know, of course, that Jerry and his family had shopped at the Westdale Mall. He said as much in his interview.
79, did you ever have reason to be in Cedar Rapids or anything like that?
Not really.
Did you go to Westdale Mall?
Oh yeah, we've gone to Westdale Mall.
Sure.
So, when you were Westdale, when you know when you would have gone out there for
Christmas shopping or, different times of the years.
Christmas, sure. Did you ever go there? Oh, I'm sorry, go ahead. Did you ever go there by yourself, without your family?
Not that I know of.
Okay.
So, no surprise, Jerry Burns and his family had been to Westdale Mall. Now, again, it should come as no surprise that he didn't know exactly where he was on December 19th, 1979. I venture to say that those of you who were around in 1979 couldn't say where you were on that date. Now, much has been made about Jerry's appearance and his candor and his demeanor during the course of this interview. And I challenge anyone to say how you would react or how I would react when faced with information from strangers coming to your office or to your home for the first time. Not only do we know that Jerry and his family had shopped at Westdale Mall and had gone there as a family, I think he said that they also had gone to some movies there. So it's not a surprise that he would know about Westdale Mall, had been there, and told Investigator Dendlinger that he had been there as fact. Much has been made about whether or not Jerry, in being questioned by Investigator Dendlinger, denied that he had killed Michelle Martinko. There's no question that he denied that he had killed Michelle Martinko. And as you see from the interview and as you saw with your own eyes, he repeatedly said that he had not.
I drank a fair amount when I was younger, but...
Sure. Do you think that may have contributed to what happened that night?
I don't think anything happened that night.
Any reason anyone would have written down your plate, your license plate? That particular
No, I
night?
wasn't there.
Yeah, well, I think we've already established you were there.
I don't think so.
We just haven't. Do you know what today is?
19th of December.
Did you murder someone that night, Jerry?
Test the DNA.
Jerry,
Test the DNA.
why did this happen, Jerry?
Test the DNA.
What happened?
I don't know.
You
I was
don't
not there that night.
You don't know why this happened?
I was not there that night.
I was not there that night. And as Investigator Dendlinger told you, not only did Jerry say he was not there that night, but he said it was not possible that his DNA was at this crime scene because he wasn't there. Jerry said repeatedly there wasn't any possibility his DNA would be there or traced to the crime. He also said repeatedly, I was not there that night. Nothing happened that night. And as I said, a note about his demeanor. How are we to know how Jerry Burns would react or how any one of us would react? We can try to put ourselves in his shoes, but the important issue is how did Jerry react and did his repeated denials establish that he did not admit, he in fact denied that he killed Michelle Martinko. We also know in the transport between Manchester when he was arrested and in Cedar Rapids, Iowa, that he was asked a number of questions, a number of which have been identified by the prosecution as incriminating. Now, we know that the audio in this interview is very difficult to pick up. We're going to listen to just a smidgen of it, and then we'll talk about some of the important words and how they were spoken.
Blackout. You think he might have blacked out? I don't think he probably blacked out either.
No, I didn't say blackout, I said things, you block things out of your memories.
Oh, you block things out. I gotcha. I'm with you now. Oh, we understand, Jerry. You don't know what's going through your mind?
I don't know what's happening.
Does that make you think about what's going on, Jerry?
Somewhat.
Okay. What are you confused about?
So Investigator Denlinger said, help me understand what was going through your mind. And Jerry said, I don't recollect. Is it possible this happened and you don't remember any of it? I don't know. I'm sure something like that would be possible to block out, for somebody to block out. Denlinger asked, help me understand what was happening. Help me understand. Jerry says, I don't know. You don't know what was going through your mind? Jerry says, I don't know what's happening. I'm confused about everything. So again, the state scenario here is that Jerry Burns, a married man with 2 young children at home, leaves, drives to Cedar Rapids, Iowa in the night, leaving his wife and children behind, armed with a knife, armed with rubber gloves, goes to a Westdale Mall on the chance that he's going to encounter Michelle Martinko, designs to kill her, kills her, muddies up the evidence the best he can, and then leaves and drives back home. Drives back home splattered with blood, with rabbit fur on his coat, presumably with a knife wound in his hand, for which we know he got no medical attention. That's the scenario the government wants you to believe. So to bolster this scenario, we have Michael Allison. Michael Allison, we know, is an informed consumer of federal criminal law. He's been convicted of conspiracy to commit mail fraud. He's been convicted of drug trafficking multiple times. He's been convicted of human trafficking, bringing illegal, undocumented workers from Mexico to the United States. He spent multiple times in federal prison. Not only has he been in federal prison, but when released from federal prison under supervision, violated the conditions imposed by the courts and his probation officers, sent back to prison, been in prison in Mexico for we don't know how long, but finds himself housed, by coincidence, at the Linn County Jail in Cedar Rapids, Iowa. And this, as you remember, is the photograph that Lieutenant Steenblock brought to us, showing the housing situation where Jerry and Mr. Allison were housed. We know that Jerry was in the bunk in the upper right, and right next to his bunk was Mr. Allison's bunk to the left. In between the 2 bunks was a box, and on that box were envelopes. Envelopes containing what are described as discovery materials. And as you know from the testimony we received from Investigator Denlinger and from Mr. Allison as well, discovery materials are the investigative reports, witness statements, other material that detail the state's investigation. Now in state court, individual defendants are allowed to have those discovery materials with them at the jail. In federal court, the federal inmates are not allowed to have that information at the jail. So in between those 2 bunks was the box with the envelopes containing the investigative reports and other material that Mr. Burns was permitted to have with him to assist in his representation and assist in his preparation for trial. Now we also know from the evidence introduced by the prosecution that the 2 cell reports, the bunk reports for Mr. Allison and Mr. Burns, that they were housed in the same unit. And as you go through these documents, you'll be able to see the dates and times during which Jerry was in the cell unit, the times during which Mr. Allison was in his cell unit. And as you compare them together, you'll be able to see that between the beginning of December and the end of January, when Mr. Allison met with Mr. Maybanks and Investigator Denlinger, that there were multiple times during those times when Jerry was not in his cell and when Mr. Allison was in his cell. In other words, Mr. Allison had access to Jerry Burns' discovery materials. He also had access to the media accounts about Jerry's case on television and in the Cedar Rapids Gazette. Importantly, you'll be able to see that over the course of the period of time between December 8th and January 28th or 29th, that Allison was in the cell while Jerry was not for more than 25 hours. Now, the Michael Allison saga also requires us to look a little bit at the chronology involving his prosecution in federal court. We know that on November 21st, Mr. Allison signed what's called a plea agreement. This plea agreement is a letter between the United States attorney prosecuting him and Mr. Allison's lawyer. And in this plea agreement, it talks about not only the consequences that Mr. Allison was facing as a federal, indicted in a federal case, but also the agreement that had been reached about the disposition of the case, how it might resolve, and importantly, the facts that supported Mr. Allison's decision at that time to plead guilty. And as you look through Defendant's Exhibit H1, which is the plea agreement, you remember Mr. Allison admitted that at the time when he initialed every one of the paragraphs in that exhibit, he agreed with the factual accuracy of each one of those paragraphs. And in that plea agreement, you're going to see the extent to which Mr. Allison is a master manipulator. He has been, in the facts of that case, been able to hoodwink his own co-conspirators, steal money from his own co-conspirators, and in fact, take money in exchange for drugs that he failed to deliver. Not only that, he preyed upon another co-conspirator in that case who was just getting out of drug treatment, persuaded that person, after they got out of drug treatment, to get back involved in the drug trade. He's a master manipulator. Now, we know on December 4th, as he told you, that he agreed to plead guilty to this federal indictment charging him with conspiracy. And in part of the agreement, he and the United States attorney agreed that he should get a sentence lower than what the federal sentencing guidelines said he would ordinarily be subject to. This agreement, called an 11C1C agreement based on a provision of the federal criminal rules, says that a judge has to agree to that sentence, and if the judge refuses to agree to the sentence, then the defendant can withdraw his guilty plea. We know that on December 6th, he met before a district court judge reviewed the plea agreement and said, I'm going to reject it. I'm going to reject it. So at this point, the judge on January 6th scheduled a hearing on January 15th to decide whether or not to allow Mr. Allison to withdraw his guilty plea and try to renegotiate another one, presumably much less favorable. January 6th. On January 11th, we know this is the date on which Mr. Allison obtained his notorious autograph from Jerry Burns. Here's a short excerpt from the video clip about that interaction on January 11th. Pointing and nodding with approval. This, men and women of the jury, was a setup. Michael Allison told his probation officer early on in a federal criminal case in California that he had lied about having a mental illness so he could get into a treatment unit in a federal prison, and that he'd used his mental illness as a bargaining chip. On January 23, just a week and a half after this autograph was obtained from Jerry Burns, Mr. Allison goes to his lawyer and tells his lawyer that he's got information on Jerry Burns. On January 28th, Mr. Allison met with Mr. Maybanks and Mr. Denlinger and told this story about what he had learned from Jerry in the jail. Just as Mr. Allison was a master manipulator throughout his criminal career, he had developed another bargaining chip using Jerry Burns. It is a concoction. Judge Hoover, in her instructions to you, has told you that in your consideration of whether or not the government's case has been proven beyond a reasonable doubt, that you must consider not only the evidence but also the lack or the failure of evidence in this case. And I suggest that there are two important things that have not been proven and cannot be proven in this case. First, we cannot conclude that Jerry Burns's blood is the source of the DNA on the dress at spot F5 or the gear shift selector, item I. It cannot be determined based on the testimony from Ms. Sauer, from Mike Peterson, from Mike Schmidt, from Paul Bush, Mike Spence. They're all in agreement that it cannot be said that that is Jerry Burns's blood. We also know that it can't be said how that DNA arrived on F5 or at item I. We know from what we've seen time and time again that the people that we touch, the things that we touch, the things that touch us are transmitters of DNA. All the expert witnesses said they cannot determine when that DNA was arrived on the dress or on the shifter. They can't say how. In the absence of those two big things, there's been a lack and a failure of evidence produced by the prosecution. The judge has instructed you about reasonable doubt. The judge has said that reasonable doubt can arise from the evidence or the lack or the failure of evidence produced by the prosecution. It's the kind that would cause a reasonable person to hesitate to act. And additionally, the evidence presented to you by the prosecution must be so convincing that you would not hesitate to rely on it and act on it. We're talking here about scintillas of evidence. And reasonable doubt, ladies and gentlemen, is more than just an instruction. Reasonable doubt is a living embodiment of what justice is all about. Reasonable doubt is an embodiment of the fact that we all know that even good people, by virtue of coincidence, by virtue of their race, by virtue of their circumstance, can find themselves unjustly connected to a bad event. We know that, and that's why any evidence has to be convincing beyond any reasonable doubt. We're talking here about evidence from a cell, from saliva, a cell that contains a partial amount of Jerry Burns's DNA. The evidence in this case must be so convincing that you would not hesitate. Not only hesitate, but you would not hesitate to act. Your allegiance, as the judge has told you, is to the law and to the facts. Your solemn obligation as jurors is to the law and the facts. Based on the uncertainty, based on the handling of the evidence, the real danger of cross-contamination, the fact that Michelle Martinko navigated throughout the Westdale Mall, areas where the Burns family had shopped. It cannot be said, with your allegiance to the law and the facts, that Jerry Burns is guilty beyond a reasonable doubt. Your verdict must be not guilty.
Thank you, Mr. Spies.